the Supreme Court has, in a unanimous decision, dismissed a case filed against the regulation of plant breeders. Parliament in 2020 passed the Plant Variety Protection Act to regulate breeders. The law makes a breeder bound to any measure taken by Ghana to regulate the production, certification, and marketing of material of a variety or the importation or exportation of the material. Food advocacy group Food Sovereignty Ghana dragged the Attorney General to the Supreme Court, contending these portions of the law are unconstitutional. The court, however, disagreed and dismissed the case. Legal Affairs correspondent Joseph Akablay joins me with more. Joseph, first, who is a breeder under the law, and what extent of control will government be exercising? For which reason Food Sovereignty took the matter to court?
So the law defines a breeder as a person who bred or discovered and developed a variety, the employer of the person or the successor of the person entitled, and it makes the breeder bound to any measure taken by Ghana to regulate the production, certification, and marketing of material of a variety, of the importation or exportation of the material. And so under this particular law, it requires that breeders apply for a plant breeder right in order to undertake the activity. As far as Food Sovereignty Ghana is concerned, they took the view that sections of the law are unconstitutional. So the first point they made against it is that it constitutes an unnecessary infringement on the farmer's right to save, use, exchange, and sell farm-safe seeds and propagating material, because they took the view that it means that should farmers be able to develop certain breed or variety of crops, they would have to obtain such certification before they can proceed to sell them. They also pointed out that it hinders their right to propagate material. The group indicated that this particular law arises from an international convention which Ghana has signed on to. And so they believe that once that's not been ratified, they cannot use the back door to pass such a law to attempt to enforce that particular convention. But unfortunately, the Supreme Court did not agree with them. But lawyer for the Food Sovereignty Ghana, George Wayo, believes the court got it wrong.
Right, Joseph.
In respect of the Plant Variety Protection Act, we all remember the Plant Breeders Bill, which had some couple of years in the Parliament of Ghana, and finally it became an act, so the PVPA. We sought to understand that the PVPA is hinged on the tenets of the UPOF arrangement. And the UPOF arrangement is an arrangement by some international state parties or stakeholders. It's not a United Nations organization. It's countries that want to go on the path of plant breeders' rights or issues of varieties of plants and their emergence. However, there's nothing that says that UPOF arrangement is part of the laws of Ghana. It has not been rectified at the time we came to court. And it's very clear in Article 75 of the 1992 Constitution that if a law, a foreign law, international law, is to be part of the laws of Ghana, it must come to Parliament for a resolution or ratification. At the time we came to court, we have not seen any such resolution of Parliament or ratification of the UPOF Convention. But this Plant Variety Protection Act, Act 1020, if I'm right, is hinged on the UPOF organization. So it's more or less like we are bringing the UPOF regime to Ghana via an act of parliament. And so we thought that it's not right. That is what the main issue before the court. And there were a series of issues in the writ as well on human rights, on issues of draconian laws in respect of people who breach these laws, as in if you breach the act. For example, you'll be sentenced to 10 years if you are holding somebody's seedlings and all that. And we know that our peasant farmers are at risk because if you bring in new varieties of plants, and that is what they must plant, and you find somebody in Wale Wale or Sehubekwai in possession of such a seedling, that is the sanction the person will get. So there were a couple of issues in this act. But the government of our case, or our main case, is that this act is based on the UPOF. And UPOF is a convention. That convention has not been rectified by the Parliament of Ghana. So how can we be made to obey an act or operate an act which tenant or which focus is on a certain convention which is not part of the laws of Ghana? And the court says we have not invoked the court's jurisdiction. But we think that a matter of interpretation, i.e., if a convention, an international convention, an international law, any law out there, which is not originally part of the laws of Ghana, if that law has to be part of the laws of Ghana, shouldn't it go under Article 75? And if that has not happened, it's not a matter of interpretation. And if it's a matter of interpretation, it's not the Supreme Court that a party or a citizen will come to for such interpretation. Yet they said their jurisdiction have not been invoked. We are yet to see the full reason, like the court said, the reasons for this ruling, unanimous ruling, will come out. And then we'll advise our clients and possibly seek a review, because we think that the UPOF arrangement is a convention. It is not part of Ghana's domestic law. And it is tried law. It's common law for everybody to know. A first-year law student who has done international law understands that domestic law and international law are different. And for international law to be received in the domestic law, that law must come under Article 75 of Ghana's constitution, of resolution of parliament or ratification. And as we speak today, the UPOF convention has not been rectified by our parliament. It has not. There's no resolution on the UPOF convention for Ghana to operate it under an act.
So that's a lawyer for Food Sovereignty Ghana. Let's now bring in Edward Karowe. He's General Secretary of the General Agric Workers Union. He joins us via phone. Great to have you, Mr. Karowe. Now, you just heard the lawyer speak about the implications of this law for peasant farmers. I just want to find out if the General Agric Workers Union has been following this issue, and do you share in his sentiments?
Well, let me say good morning to all of you. And I think that as a General Agricultural Workers Union, we have been part of this thinking that the law, the Plant Breeders Bill, its content and its intentions are not favorable to the Ghanaian farmer. It's not favorable to the Ghanaian cause of trying to be independent and then control its means of production. You know, in fact, we've seen the law as a form of subjugating the Ghanaian farmer and everybody under its control, under foreign control. You know, apart from the legalities, where the Supreme Court said that their jurisdiction was not properly invoked, and then the reasons are yet to come. Apart from that, you can just see that why should we have a law that will punish the ordinary peasant farmer just because he has shared some seed with somebody else, which is claimed to be a seed from either a multinational or somebody they call a breeder. You know, and the punishment for the violation of the law is also punitive. And I don't understand why matters of this nature, which are not hardcore criminal offenses, why should they receive such a severe punishment? And apart from that, if you look at this country, the peasant farmer population and their contribution to food production in this country is so huge. Up to 70% of domestic food production is by these peasant farmers. Now they can no longer share and distribute their seeds with other people because the seed has been patented by somebody else. And we all know some of this knowledge is an indigenous knowledge. It has been transferred to us from our ancestors, from our grandparents, and it's communal knowledge. Why should we now be made to, the communal knowledge is taken away from the community, and then it now becomes criminal. You know, this is another form of human rights abuse, because the farmers have the right, you know, to keep their knowledge. And just one day, someone from somewhere comes to say that, oh, this knowledge, I've patented it, therefore, they do not have access to that knowledge, they cannot use it, and when they use it, then it now becomes criminal. So it borders on human rights violation. It borders on constraining the ability of this country to be able to produce and feed themselves, and then also to feed the rest of the world.
Mr. Karowe, we just heard from lawyer of Food Sovereignty Ghana, which went to the Supreme Court over this case. They're waiting for the full decision, and they will advise themselves based on what they see in there. But what is the General Agric Workers Union also going to do, since you clearly agree with the sentiment of Food Sovereignty Ghana?
Well, once the Supreme Court has given a decision, and they are yet to give their reasons, whatever reasons they give, it means that that's the apex court, and their decision is final. I think you've heard the lawyer also say that, look, they may request for a review of the decision. And that is what we can do, because if it had been any other any other court, then we could be seeking an appeal at the highest court. But here is the case: the highest court has dismissed the case. And in fact, I am excited that they are not necessarily saying that, without prejudice to the reasons that they are giving, is that the court's jurisdiction is not properly invoked. What it means, this is a technical, argument, that even if you have a good case and you have not come to us, appear before us properly, then you will not even, we will not even, consider your view. So that's what it means for me.
So you're hopeful that if another court or a lower court sits on this case, you could have it in your favor. You could have a decision made in your favor. And I'm saying because you say you agree with Food Sovereignty Ghana's position on the matter.
Yeah, per the court structure in Ghana, no other lower court can sit on this case, because the structure is from lower court to higher court, and then the Supreme Court decision binds on every court in this country, which are lower than.
I appreciate that, but it's because of the jurisdiction issue that we've just brought here. That's why I'm saying a fresh case can be filed in relation to the plant breeders bill in a different court, right? Because the Supreme Court says that its jurisdiction was not invoked properly.
Well, I think the legal team will consider the possibility of that, and then one of the possibilities is to ask for a review of their own decision. The Supreme Court can review its own decision, and then say, look, where we have erred in our earlier decision. But as to whether or not, once it has gotten to the Supreme Court and the Supreme Court has given a decision, same matter can be put before a lower court. I believe I will leave that one for the legal team to explore. And then, as I said, we are totally in support of food sovereignty. We think that the law, in its present terms, is not a good law for Ghana. It's not going to promote agricultural production. It is going to impoverish the already poor farmers, and it is going to take away their fundamental right, to own their own seed and then also share that seed with other people.
Thank you for your time this morning. Edward Karawe is General Secretary of the General Agric Workers Union there.